I'm really pleased to welcome everyone at this session. I will deliver some kind of meanwhile in Russia content here. So it's not an easy case actually to speak about regulatory changes in Russian environment, because this topic is quite controversial, and it's not an easy task to find a middle ground for a lawyer who prefers to operate with facts rather than value judgments. But I would like to try to do this, although it would be quite complicated, because IT and intellectual property law practice in Russia is by far not standard law practice. And for example, one of the most remarkable cases which I had this year was heard in one of the very simple courts of general jurisdiction, you know, those courts which usually deal with simple claims of citizens. But due to jurisdictional rules, we actually represented there an American IT company, well, frankly speaking, it was a giant, against a local Russian user who claimed a kind of user-consumer claim, user-consumer demand to this company, and it was really intricate and very hard. But what was really important about this case? It was that the user agreement established jurisdiction of English courts over the case, but Russian court recognized Russian jurisdiction over this particular situation. This is a new trend in Russia, and frankly speaking, we can summarize it that Russia is currently learning a lot from United States in long-arm application of statutes and laws. And the first area is internet, and so far this area concerns the games as well. So Russian courts will not easily give up their jurisdiction, and this makes Russian law out of a sudden relevant for anyone who is particularly interested or engaged in Russian market, doing IT business, operating stores, and delivering computer games. So these are several criteria which are currently being developed in course of official discussions and are partially recognized by Russian legislation. And in summary, we expect that in nearest future, Russia will recognize more and more cases where Russian courts will have jurisdiction. The first principle is that if a company operates with a certain domain name which is associated with Russian space, for example, RU or RF in Cyrillic, of course, it would be a sign that there should be jurisdiction of Russian laws. The second one is apparently language, and the Ministry of Mass Communications, which recently published information about how it sees the application of foreign laws, of Russian laws to foreign relationships, mentioned that this language should be genuine. So the website or the application should contain Russian language as its natural language and not just some kind of automatic translation. Then if the transactions which users do can be made in Russian rubles, this is also the second sign of Russian jurisdiction. Finally, delivery of content and advertising of this content in Russia are also possible signs of Russian jurisdiction. Why this can be important, actually? There are a couple of important and relevant stores. There are a couple of game services and other IT infrastructural services which actually could be subject to Russian jurisdiction because they consistently target Russian market. But so far they have no corporate representation in Russia, and all of a sudden they may face some regulatory action. And this is true for all kinds of information. Games, online stores, IT infrastructure, companies operate with information, and since about 2011, Russia has very intricate regulation of information, including various grounds for information blocking. These rules are probably quite notorious in current environment as far as we speak about Russian regulatory regime for the internet. This includes actually a couple of situations, and the first one is in fact consumer rights protection. So this was the first strong jurisdictional rule in Russia, and if the company could be considered as target in Russian market by any sense, it can be subject to Russian law. And this was exactly what happened in the case where we participated as legal representatives. Then probably one of the most topical issues is privacy and so-called personal data legislation. I would say that about 60% of my work recently during this year was dedicated to appraisal and ways to developing ways to mitigate legal risks associated with operating with user data by foreign companies because of this so-called localization amendment, according to which personal data of Russian citizens literally should be operated and stored in Russia. So this is a quite important rule which will probably yet reveal itself. It is active from 1st September 2015, but so far we haven't had seen any really strong application of it. Well, I hope that copyright owners of South Park will not sue me right away for using these images, and I can rely here on the fair use of them, but this is also a remarkable case. Last year, Russian authorities started to refer to Russian age ratings legislation. This is particularly relevant probably in the field of games because last week there was quite an interesting news from one of the experts of Roskomnadzor, a Russian authority which controls internet and supervises mass communications, that Russian experts will work on establishing ways of preliminary control of game information, so preliminary control of age ratings. And this is also a very interesting development. That was quite an interesting case, and it is accessible on the website of Roskomnadzor. And South Park actually was checked whether its age rating of 16 plus, which it has in Russia, is fine. And that's interesting. There was a whole 19-page expert examination report which finally stated that it is okay, that every sign of extremism in hyphens which can be seen in South Park actually is ironic and is used as a special literature means to convey some positive social sense, and probably this is a good development. I mean that, mostly, well, reasonable approach to application of Russian laws. Ultimately, there are also other kinds of information prohibitions and limitations which may lead to bans of websites and apps. And generally speaking, they can be divided into two main categories. So the first one is offensive content, and to a large extent it's quite reasonable. Because, for example, this category includes child pornography, which is banned in most of the countries, and it includes information about narcotics, drugs, but there are some peculiarities which are available only in Russia, of course. For example, a kind of offensive content is content about suicide, so information about the way to commit suicide. It's very interesting how this could ever be applied in games, where you can just, in some cases, type suicide comment and suicide your character. But not less important is the aspect of intellectual property right infringement. Since this year, since May 2015, companies and individuals operating in Russia received the right to apply for Moscow City Court, which is a specialized court in Russia dealing with internet issues, to apply for preliminary blocking of information, of any kind of information which breaks intellectual property rights. Not all companies actively use it to protect their IP, but we already had several examples where game companies already applied for this resort. So mainly it is used currently for blocking of the information within pirate torrent networks and so on, but actually this has also a positive effect. This outline shows the intricate procedure which is happening when a decision on blocking of a web resource or application in online store happens in Russia. So in the center there is Roskomnadzor, the authority which affects technical solutions for blocking of the websites. And to summarize, in most cases, according to our practice, we deal with this on a regular basis. Roskomnadzor usually tends to more or less weighted approach, and where possible, it tends to contact beforehand the owners of websites and applications to try to deal with the issue on a friendly basis. This is not a general rule, and they are not obliged to do so, but actually they understand that very harsh measures in informational space may lead to very bad consequences. Well, the probably important conclusion from this particular slide could be that when a company abroad receives a strange notification, which is both in Russian and in English, and if it is interested in Russian market, probably it is worth it to pay attention to this. The iterations between several blocks here take, according to law, depending on procedure, but about 1 or 2 days. So an application can be blocked or unblocked in the matter of about 5 to 7 days, concerning how information transfers from all these parties. So this is one of the, well, quite important aspects of Russian internet regulation right now. The second one is personal data. The companies operate with user data which is not, according to Russian standards, always could be considered as personal data. And here, although Russia relies on the same regulation as European Union, usually it has, in practice, more narrow scope of data. So, according to Russian legislation and practice, anything which can actually identify an individual is definitely a personal data. But user data which does not allow to identify a specific natural person has high chances for not being considered as personal data. And current monitoring of court practice shows this. Returning to the aspect of personal data localization, this actually caused a lot of discussions, and probably there was no law before that which raised so much discussions during last year. Actually the rule is indeed quite short. So personal data of Russian citizens should be stored in Russian Federation. This is important rule because otherwise the companies will also again face the threat of website blocking, but there are also several important notions here which may make situations easier. The first one is that it relates only to personal data, not to all user data, including technical data. And the second one is that, strangely, but the rules which allow cross-border transfer of personal data from Russia to other countries are not abolished. So basically this rule means that there should be a kind of data center for personal data of Russian citizens, and it should not be necessarily something which belongs directly to the company which operates with this data. It can be an outsourced, for example, service, but there should be something. And current situation with personal data is not that probably good as it was before, if we rely on assessment which business gives to this situation. There is different approaches to United States and European Union and Russia, because formally Russian government considers United States as a country which does not provide, so to say, adequate protection of personal data, unlike European Union. And now it is quite topical, of course, to consider also the issues of well, disputing safe harbor clause between United States and European Union as well, because this leaves the possibility to transfer data first to European Union quite unavailable. So situation most likely will be a bit harder in this respect, as it would require additional documentation to effect a transfer of personal data between different companies. Finally, if we consider the gambling aspect, this is also quite an important area of practice which concerns informational field in Russia. Frankly speaking, right now regulatory action concerns only those services which are apparently gambling, and gambling is defined in Russia as a risk-based agreement on a price, so there should be some property received by a participant of such game, and if it is just an element of luck without any substantial consideration received, then it is not that risky to operate. But services which are used to cover gambling under, for example, the image of an ordinary game are also subject to regulatory control. So to summarize this particular aspect, risk-based solutions in games, which especially include some kind of possibility of cashing out or receiving some kind of material benefit, currently constitute a risk area in this particular aspect. To summarize this presentation, probably there are good news, which are that games are still not taken seriously in Russia. So there is not any single very broad example of dealing with information blockings and so on in respect of games. But still games are starting to gain regulatory attention, and most probably everyone who is interested in Russian market have heard about Mail.ru case, which had a big dispute with Federal Tax Service, and they discussed actually a lot of VAT reimbursement aspects. There was a big amount connected to virtual property, and it was interesting that there was really deep dispute between Federal Tax Service and Mail.ru about what is the nature of virtual property. Mail.ru insisted that it is IP, while Tax Service insisted that this is a service on organizing, so to say, game process, and the latter position actually won in court. And basically common sense and knowledge of peculiarities may really guide you in course of dealing with the Russian market. But still it is recommended to be aware of local interesting aspects of law, and interesting probably they are to lawyers mostly, but not to people from business. Well, I would like to stop here. Thank you very much, and if you have any further questions, I will be really pleased to answer them.
I actually have a question for you. If the Russian government or a regulatory agency therein did choose to act against one of our companies, about how quickly could you expect them to attend to a perceived violation?
That's a really good question, because this procedure, on the one hand, this procedure is quite specifically drafted in the law, and generally it takes about 7 days, considering all that interactions between various divisions of Russian authorities. But in fact, it will be, there will be a gap about 2 or 3 days to take measures actually to comply, unless Russian authorities, and they do this actually in fact, unless they decide not to go under this official procedure. Usually they do this with very socially important or business important big services. So for example, when we had problems with Live Journal, which is a big and popular blogging service in Russia, they managed to deal with this problem much faster and without without involving a lot of serious blocking of web resources. So it would be quite fast. So it is recommended, if you value somehow Russian market, to react somehow in the first day.
So is there an appeals process that someone could apply for or could apply to?
Oh, that's a good question also. But if we take the hardest version of this procedure, the appeal could be done in court actually. So in the first case, you either agree or disagree with this decision, and if you comply, the potential banning is lifted. But if you don't agree, it will be banned by telecom operator, and then you can go to court. So this is the area of widest criticism here.
It sounds like arbitration agreements may be some way off then.
More or less so. But if we speak about IP claims and bans of information due to IP infringements, this procedure is from the beginning made by court as a kind of preliminary measures before filing a lawsuit. So this gives more flexibility to parties.
Thank you.